So I think we could probably get underway now. Good morning for some, good afternoon for others. We have people from West Coast and East Coast on this Zoom call. First of all, on behalf of CPT Group, myself, I'm Ryan Schley, and Alan Rock, Nick Day, and Timothy Phillips, my colleagues in the Bankruptcy Division at CPT Group. We'd like to thank you for attending the second installment of what is basically the practicalities of Subchapter V proceedings. A little bit about CPT Group, for those of you who don't know as well. We're a notice and claims agent. We're approved in every court in the United States. We focus on a no surprises pricing model. I know that that's something that comes up a lot where you get the big sticker shock pricing 2 months into your case. We try to minimize that as much as possible. We're located in Irvine, California, which gives the people on the East Coast an extra 3 hours for last minute notices. All of our operations for both notice and claims are in-house, including all of our state-of-the-art equipment, which allows us the flexibility to take care of last minute notices and things like that and still get them out on time. So that's a little bit about CPT Group. We'd love to work with each and every one of you. Next time you have a case, please give us a look. We'd really appreciate it. Now I'd like to introduce Michael Jones. Michael, who's our instructor for this course. Michael has had a bankruptcy practice for over 25 years in California. He's handled multiple Subchapter V cases. He's a CLE instructor. He's a published author with multiple articles specifically on Subchapter V. So he's a great resource for us and a great resource to teach this course. And with that, I'd like to present Michael Jones.
Hey, so good morning for you West Coasters and afternoon for everybody else in the nation. So this is a 3-part course that we're doing. And the goal here is to kind of break things down to enable a person who is a Chapter 11 practitioner to be able to do a very, very effective Chapter 11 plan under Subchapter 5. So the first time around was essentially an overview of the differences between a traditional Chapter 11 and Subchapter 5. Today, we're going to begin looking at a lot more of the actual nuts and bolts and the drafting of an actual plan and the process by which we're going to get it confirmed. So what I'm going to do is I'm going to share my screen so that we've got the ability to kind of go through some slides together. And I'll tell you that these slides will, in fact, be available to anybody who wants them. So if you decide that you'd like to get these slides a little bit later on, that'll be, of course, fine. Let me get my slides back. So just again, let me know what you'd like and or if you'd like them, and we'll pass them along. Okay, so just quickly by way of review, but I do want to tell you, if you want to get more depth on this, please go back to watch part 1. Okay, but just by way of review, if we look at a Subchapter 5 plan like it was a trip, there's the planning stage of deciding where it is we want to go, and then think of it like a plane ride. There's the takeoff, the cruising at altitude, and then the landing. So the takeoff is getting out of the gate. How do we get this thing off the ground? Typically, a Sub 5 case is going to be brought as a voluntary petition. It is possible, I suppose, that you could have an involuntary petition that you then elected Chapter or Sub 5, but it's probably going to be a voluntary petition. When you're at the cruising phase, that's where we're going to be negotiating with creditors on plan treatment and things of that nature. And then when we get down to the landing, that's confirming the plan. And confirming the plan in the Chapter 11 Sub 5 world is, in fact, a different animal. Just to give you by way of preview, we'll look at this mostly in our 3rd lesson. But one thing that's really different with a Sub 5 is you don't have a disclosure statement. You might, the court might order one, but typically the disclosure statement-like elements are simply incorporated into the main Chapter 5, Sub 5 plan. So what ends up happening in a Subchapter 5 case is, because you don't have a disclosure statement hearing, then the question comes up, well, then how do you get like the dates for your confirmation hearing? How do you know when ballots are due and those kinds of things? And typically that's done by motion, where you have the court establish the plan confirmation process. Okay, so here's here's what a sub 5 plan looks like kind of working its way through the system. And for those of you who are, in fact, Chapter 11 Debtors Counsel, which is probably most of us, you'll notice that this thing goes like really fast, okay? From the time that you file the petition, the code requires there to be an initial status conference within 60 days. In real life, that's usually the time that the court's going to be grilling debtors counsel as to what steps are you making towards getting a consensual plan in place. Then you're required, again, by statute, to have a plan filed within 90 days. Not a disclosure statement, but a plan. And then, again, you go through the process of getting that plan confirmed, and we'll look at that next time. 28-day minimum for balloting. In practice, it's usually 30 to 40 days. And then there is normally a confirmation of a plan within about 6 months. So again, you go through this thing like at a crazy, crazy fast pace. So some of your differences between a traditional Chapter 11 and a sub 5 is a sub 5 is kind of designed like a Chapter 12 for a non-business or rather a non-farm business. Okay, so it's designed with truly the small business in mind. You have debt limits. The debt limits are about 7 million or so at this point. It's going to drop down to a little over 2 million again in March of next year if we don't have a change on that. There's no absolute priority rule in sub 5. You can obtain confirmation of a sub 5 plan with no creditor consent at all. In fact, if you get no ballots returned, not a single one, you will still be able to confirm your plan. We'll look at that today. But oddly enough, you are effectively entitled to have your plan confirmed. The bankruptcy code says the court shall confirm the plan. So again, we'll look at that here in a moment. There's a new participant. We'll look again today at how we're going to use that guy to our benefit, and that's the Subchapter 5 trustee. We do have the ability to adjust debts that are secured only against the debtor's residential real estate. That's similar to a Chapter 12. There are no competing plans. There are no creditor committees, except in rare circumstances. I've never seen a sub 5 with a creditor committee. That doesn't mean there aren't any. I just haven't seen one. And again, the idea is to streamline these things. So they're probably moving too fast for realistically anybody to do one anyway. Also, there are there's a big difference between a consent plan and a non-consent plan. There's a difference as to how creditors are paid, the trustee's role in that, and when a discharge is entered. Okay, so these are kind of the big overview issues within the sub 5 chapter world. Now, let me pause here for just a second and say this. As we're moving through this at the end of our time today, we're going to have some Q&A to deal with specific issues that people might want to know. I would encourage you to type out your question in the chat, and then that way it'll be there. So when it pops into your head, go ahead and fire it off into the chat section. And then we'll have that when we get to our Q&A part. But please feel free to ask whatever questions you want to do that will help you to understand the process or to smooth it out for you along the way. All right, now our new material. Let's get this thing out of the gate. Okay, let's do the takeoff. If we want to consider a Subchapter 5 case, we have to make sure we're eligible to do that. Okay, so in a Subchapter 5 world, the debtor has limited eligibility. So again, think about Chapter 12. To be a Chapter 12 guy, you got to be a family farmer or a fisherman. To be a sub 5 debtor, you have to be a small businessman as it's defined under the code. So when you look at Subchapter 5, we need to make sure we've met the definition of the debtor. Okay, so there are some nuances to this that have not yet been fully wrangled out in the court system. Okay, so sub 5 is just too new. There aren't a whole lot of appellate actions on sub 5 yet. One of the areas where there is a question about eligibility as a debtor is in regards to whether or not your business has to currently be operating. Okay, let me show you the issue. On the screen there is 1182. This is the definition of debtor for Subchapter 5 purposes. And you see the little highlighted part that I've got there? It means a person that's engaged in commercial or business activities. Okay, here's the issue. It doesn't say you have to be operating a business. It just says you have to be engaged in that. So if the business has already shut down its operations, but you're still going through the shutdown process, the wrapping up phase of the business, the vast majority of courts throughout America would say you are still engaged in business activities because the wrapping up counts as engaged business activity. Now, the courts are not uniform on that, but it seems to be that about 90% or more of the courts hold that view. But just be prepared that you might have to fight about it. My recommendation for you is, as you're drafting your paperwork and you're given the narrative about the history of the debtor, be careful to qualify that you are currently engaged in business activities. That way you'll be able to fight off any kind of opposition to say you shouldn't be a sub 5 debtor. Creditors might not want you to be a sub 5 debtor because you're going to confirm your plan and they may not want you to confirm a plan. So they may fight to get you out of that, but that is an issue. Okay. You're also going to want to make sure that you're under the debt level. So right now it's $7.5 million. That's as a result of the CARES Act. In March of 2023, it's going to drop back down to 2.7 million unless Congress enacts that as a permanent change. We don't know whether that's going to happen or not. I kind of have a gut feeling that it probably will, but we don't know yet. So right now in your planning, just be prepared if you're coming up on that date and you've got somebody who's got more than 2.7 in debt. You're either going to want to file your case super duper fast or check and make sure to see whether or not they've retained that. And then of course you can't be publicly traded. And the reason why I say, of course, is because remember the goal in sub 5 is kind of the small family business. That's kind of what we're looking for. Okay. Now, what happens if you file your case, but you don't elect to be a sub 5 debtor? The way the election is made is on the voluntary petition itself. Okay, when you go through the voluntary petition and you check off that you're filing under Chapter 11, there's going to be another question as to whether or not you want to be a sub 5 case. What if you don't check it? Can you check it later? And the answer to that is, yeah, you can, because the bankruptcy system allows, fairly liberal amendment of petitions and schedules. And so here you're actually amending the voluntary petition. But you have to be careful of something. Under the Subchapter 5, there are a lot of deadlines that hit. And like we looked at the course of a sub 5 case, how it rattles through the system really, really fast. The first deadline that's going to pop up and bite you really hard if you haven't planned for it is the requirement to have a plan filed within 90 days. Okay, here's the code again, as it relates to the filing of a plan. Okay, so this is 1189. It says the debtor shall file a plan not later than 90 days after the order of relief. All right, it does say the order of relief under this chapter. So that would be Chapter 11. And the bankruptcy code, you'll recall, says the filing of a petition is an order of relief. So if you file a petition and designate Chapter 11, you got 90 days to file a plan under sub 5. So the issue here again is that you'd have to file a plan within 90 days of the filing of the petition. So if you file your case and then you late elect to switch to Chapter 5, just be prepared that you may have missed the deadline if you're more than 90 days. And the code says that you can get an extension of that. But again, as it's highlighted here, only if the need is attributed to circumstances for which the debtor should not be justly held accountable. So if it's not your fault that it's being filed more than 90 days late, it's okay. But most courts are holding that a failure to elect sub 5 treatment until late in the game is your fault. So you can't do it. Okay, so but there is a mechanism to do it. You just amend your voluntary petition to elect that sub 5 category. All right. So again, back into the kind of the, okay, let's make one of these things actually work. All right. So we got a new sub 5 trustee. We're going to use them to our benefit as debtors counsel to confirm a plan. More on that in just a moment. We have this amazing ability to adjust debts that are secured only against the debtor's primary residential real estate. And let's talk about that one for just a minute. Here's what the code says. So this is 11 USC 1190. And it designates under item 3, subcategory 3, that notwithstanding 1123 B5's restriction, the debtor may, in his plan, may modify the rights of a claim secured only by a security interest in real property that is the principal resident of the debtor. He may do that, but there are a couple criteria. So the first criteria is that it has to be debt that you're adjusting that was not used primarily to acquire it. In other words, it can't be purchase money debt. If it's not purchase money debt, then we meet the first hurdle. The second criteria is it has to be used primarily in connection with the small business of the debtor. So what does that mean? Well, it could be a couple things. It could be that you're running a home business. And if you're operating a home business and you got your home office there and that's your base of operation and you keep retail inventory present or you meet clients there and things of that nature, you're probably going to be okay. Or it could be like this guy. Okay, so there's a provision right there from a real life sub 5 plan. It was filed in New York. And what happened in this case is they're adjusting the mortgage on the primary residential real estate of the debtor because they use that property as a bed and breakfast. So the New York law required the individual to live at the property for it to be used as a bed and breakfast. So they lived there and they used it primarily for that purpose. And the debt that they're doing was like a refinance or something. And so there you have a debt that's secured only against the debtor's primary residential real estate, but it is for business purposes and it wasn't an acquisition loan. And so they did fight about that. And the court held, nope, that's fair game under Subchapter 5. So there you go. Another basis is even if it was purchase money and then you refinanced the property and took a cash out that's used for business purposes, again, you're going to be in a unique position to where you'll be able to modify that loan. Okay, so being able to modify a loan on real estate is a gigantic advantage in Chapter 5 or Subchapter 5. And even if it's your residential real estate, if you jump through the right hurdles, you can get it. All right. Now, another key difference is there's no absolute priority rule. And you'll recognize that that's under 1129B. But the bankruptcy code says under Subchapter 5 that there's some provisions of the bankruptcy code that are not applicable in subchapter 5. And one of the ones that's not applicable is 1129B. Well, that's the absolute priority rule. It also happens to be the cram down provisions for chapter 11. So if you take that out, how do you confirm a plan where you don't have unanimous consent? It's done under the provisions of subchapter 5. So that's 11 USC 1191B. And we'll get to that here in just one moment. What this enables us to do under 1129B is to confirm a plan with no votes at all in favor of your plan. In fact, everybody could vote against your plan. So you'd have a bunch of hostile creditors, but even if they're voting against your plan, you're still going to probably confirm it. And this is one of the big, humongous reasons why people like to file subchapter 5. Here's the code. So this is 1191A that deals with a consent plan. Okay, if you qualify, everybody consents, great. And then there's provision B. Okay, so provision B says, as long as we meet all the requirements of 1129A, except for 8, 10, and 15. Okay, well, 8 is the unanimous consent chapter or the provision. 10 says at least one class votes in favor of your plan. 15 is for the individual debtor that requires them to, if you have a creditor object, to pledge all of their disposable income. So we don't pay attention to those. We don't have to pledge our income for 5 years if you're an individual debtor, and we don't have to have even one consenting class. And then this provision, on the request of the debtor, the court shall confirm the plan. Okay, so as long as we meet the requirements for confirmation, even if every creditor says we hate this plan and don't want to do it, the court shall confirm it. So what are those criteria? 2, at least within that exact provision. Okay, and then there's the requirement for protected creditors too. We'll get to that as well. But he says that the plan, first, does not discriminate unfairly, and second, is fair and equitable to each class of claims. Okay, so those are our 2 criteria. Doesn't discriminate unfairly and is fair and equitable. Now, if you've got a copy of your code handy and you're inclined to annotate things, you should put a big gigantic star next to the phrase fair and equitable to note that fair and equitable is defined for subchapter 5 within 1191, and it's different than what you find in other chapters of the bankruptcy code because it's relatively methodical. As long as you do what they say, it's fair and equitable. Okay, so here's how this is kind of shaking out. So the first criteria, it has to not discriminate unfairly. Okay, now I want you to please note that it's not that it doesn't discriminate. It just can't discriminate unfairly. If you can justify why it's fair for it to discriminate, you can. Okay, you just got to convince the court of that. But there's a little bit of casework on this below that largely says discriminate unfairly is the same standard that's under 1129B because it's not redefined in subchapter 5. But fair and equitable is. Fair and equitable is redefined in subchapter 5 in section C. Okay, so here it is on the screen again. So we got section C and a rule of construction that says, for purposes of this section, the condition that a plan be fair and equitable includes the following. And down below, we've got the requirements here that the plan provide all of the projected disposable income of the debtor in a 3-year period. Okay, and now it does include a provision that says, or such longer period, not more than 5 years that the court may require. So the default is 3 years. If a creditor objects and says we should make it 5 years, the court might make it 5. But typically the default is 3 years. Okay. And it has to be a pledging of all of our disposable income. Okay, so if we pledge all our disposable income for 3 years, provide for protection of the creditors, the unsecured creditors typically, then we're going to meet the fair and equitable standard. And 1191B says if we do that, the court shall confirm the plan. Okay, so again, you've got great power as a debtor writing a sub 5 plan, in that you can get it confirmed even with nobody voting in favor of your plan. So then the question becomes, well, then why do we care if it's a consent plan? You care if it's a consent plan because there are benefits to it. Let's talk about drafting this thing out. Okay, when you're actually writing the plan, you have to keep in mind some of the real specific things that are unique to sub 5. For one thing, there's no disclosure statement, but 1190 provides that you have to include the kinds of things that are normally in the disclosure statement. You have to include the history of the debtor. There has to be a detailed liquidation analysis. And there have to be the projections as to what do you think is going to happen moving forward. Because you don't know if you're going to have a consent plan or not, unless it's a prepackaged plan of some kind, you probably want to write your plan with an idea that you're going to have to seek 1191B confirmation. So make sure that your parameters meet the requirements of an 1191B confirmation, which means you're going to pledge all your disposable income for at least 3 years, maybe 5, and you're going to provide some protection for your unsecured creditors. Now, how the projection or protection we're going to provide is going to be covered in our next session, but just kind of keep in mind that that is one element that has to be there. Your plan needs to go through this planning. Okay, the very first thing you need to do is make sure you define disposable income. You've got some leeway in that because you're going to be the one drafting out the budget, which means you're going to be the one proposing what you have to spend and then what's left over. So you can kind of play with that a little bit to make sure the numbers work out to what it is you're wanting to do. Then you got to make sure you pledge that disposable income, the excess amount over your normal budget for 36 months and provide the protection. As long as you do that, you're good. So what is the disposable income? All right, it's defined in the code. So this is 1191D. Okay, here's what it says. Disposable income is income received by the debtor that's not necessarily expended for the maintenance of the debtor or a dependent of the debtor, or domestic support obligation. And then look at the second item there. This is the one that gives you a lot of flexibility. It also doesn't include money that's reasonably necessary for the continuation, preservation, or operation of the business of the debtor. Well, that's really vague, okay? And enables you to have a lot of flexibility because you can argue from the debtor, he can provide evidence of his own that says, I need that to be able to make sure I can keep practicing and in order for the business to continue functioning. All right, on the screen is a page from a real sub 5 case. And this is the projection requirement that's required. and it's designed to meet the fair and equitable requirement. So you'll notice it's set up for 3 years. You'll notice in the middle where the expenditures are listed that there's a category called reserve to ensure continued operation. That's essentially your slush fund that says, I want to hold some money back so that it's there if I need it. I might need it for some unexpected marketing program I need to do, or I might need it because we need to adjust for inflation or something that's happening here on the West Coast anyway. I might need it to buy emergency supplies because what I normally get for my supplies for my business are stuck out on a shipping cargo container and I can't get it into port. So you just hold that back as a reserve. And then on your projection at the bottom where it shows the surplus, you'll notice the surplus here is a big 0. Why 0? Because 1191 requires that you pledge all of your disposable income to the plan. So we pledge it all in the treatment of the various classes. And then we meet the 1191 requirement. If we do that, you're going to find yourself in really good shape. You'll be all good to go, and you'll meet the requirements of 1191B for a confirmation, even with no consenting class. Now, you do have to provide for protection of unsecured creditors. And again, that'll be next session. But just by way of introduction to that, here's the provision in 1191C. It says that you can convince the court that you will do it. You will perform. And about the only way you can do that is if you have cash reserve sufficient to pay all the claims immediately. Then the court's going to say, okay, you're going to do it. Otherwise, you're going to be using this provision 3B, which requires for appropriate remedies that might include the liquidation of non-exempt assets. Doesn't have to, but it might, to protect the holders of claims in the event that you default. So if you default on the plan, you got to provide some kind of remedy to them. All right, so just a little bit more, and then we'll go to have some Q&A. All right, how do we get to a yes to a consent plan? Well, three methods that'll usually get you there. Okay, the first is to enlist the sub 5 trustees' help. The bankruptcy code says that the sub 5 trustees' duties, and that's them there on the screen now. Look at item 7 in the enumerated duties. Facilitate the development of a consensual plan of reorganization. That effectively means the trustees on your side work together to come up with terms that the trustee says, I can sell this to your creditors, and then get the trustee to do that. One reason why that's going to be really helpful to you is creditors might listen to the trustee when they ignore you. Okay. And so if you follow it through like that, then you'll be able to get the trustee to help you get your confirmed plan by getting consent. If you don't get the consent, you may end up paying that sub 5 trustee a lot of money because he stays in the case as a payment conduit, paying everybody. And you're going to pay that guy for the next 3 to 5 years. So better off to enlist his help now and get your plan confirmed as a consent plan. Another method you can use is what I call a friendly death trap. Okay, so a death trap is kind of Chapter 11 lingo for a provision that says, vote for my plan or else. If you want to get one that's your judges are comfortable confirming, use one that rewards creditors for saying yes instead of punishing them for saying no. And you're probably not going to get a judge willing to confirm your plan if you're taking away rights that the creditor is otherwise entitled to, like their minimum payment under liquidation analysis. They're not going to do that, right? So instead, give them a bonus. And what makes this friendly is you can also include provisions that say that the creditor's treatment, the class treatment, is only impaired if they vote for the plan. If they don't vote for the plan, you're going to leave them unimpaired, because 1126 says if they're unimpaired, they are conclusively presumed to accept the plan, which means you're on your way to a consent plan. Now, that does also mean that you don't get any kind of ability to adjust their treatment. So you have to kind of weigh whether or not what's more important to you, being able to change their treatment or getting a consent plan. But it's up to you when you're drafting the plan as to what it is that works best. Here's a couple real plans. So the first example there in the top left, this one here, what this says is if the class votes if they vote against the plan, or they don't vote at all, then they're just unimpaired. We don't change them. Okay. And then the next one says that if they do vote in favor of the plan, we're going to give them their regular treatment plus $500. So they're left unimpaired really either way, except for giving them $500. This just gives you the ability to have a class that votes in favor of your plan so that you can go to the court and say, oh, at least some creditors like our plan. The one on the bottom right is a little bit more in line to what we're talking about, though. This is one where a creditor is only modified if they vote for the plan. Otherwise, they are completely left unimpaired. And this was from a plan related to a commercial landlord where they had already worked out a deal with a landlord and they wanted to maybe tweak it more. And the landlord might not want that, but we needed to confirm the plan. So what the debtors council did in this case is they drafted a provision that says, if they're okay with it, then we modify it. If they're not, we just leave what we've already worked out intact. But that's a friendly death trap. And then the last method is to create an actual incentive fund. This one literally pays them to vote for your plan. The reason why you do this is it's cheaper than paying the trustee for 3 years or 5. Calculate what you think the trustee is going to make, and you're going to have to pay them over 3 to 5 years. Take like 65% or 70% of that number, set that aside to fund an incentive plan, an incentive fund, and then share that fund with the creditors if your plan is confirmed under 1191A. Okay, here's that provision a little bit bigger. This is from a real sub 5 plan. And you'll see that class 4 has this incentive plan. And it's explicit. Incentive to vote in favor of the plan. If we don't do it, and it explains what's going on. Hey, if we don't confirm under 1191A, we got to pay a trustee. It's going to cost us money. So instead of doing that, we'd rather give the money to the creditors. So if we confirm under 1191A, then we're going to take $5,000 and set it aside as an incentive fund. And then if and only if class 4 votes in favor of the plan and the plan is confirmed under 1191A, then each creditor in this class not only gets their treatment, but also a pro rata distribution of the incentive fund. You literally pay them to vote for your plan. And then if you confirm the plan, you get an 1191A confirmation, the creditor gets paid, the debtor pays less than they would otherwise do. The sub 5 trustee drops out of the case, you get your discharge entered, and you're probably about 60 or 70 days from closing the case and being done. So everybody usually likes this approach, right? The court gets to close the case. It's a confirmed plan. It's a consent plan. Creditors get paid more. The debtor saves money that they'd otherwise pay. Everybody kind of goes away happy. All right. So that's a little bit of the plan drafting consideration issues. So let's go now and have some Q&A time. And it looks like we've got a bunch of questions already. So let's just kind of work through them and see what we get. Okay, so the first question is, will we be providing written materials? Yes, I will send out my slides to anybody who wants them, including the gentleman here or the woman here who's asked. All right, and then the second one talks about the debt cap. Okay, so the question says, regarding the debt cap, the statute says that it's assessed by non-contingent liquidated debts. What if the debtor faces significant unliquidated liabilities that exceed the $7.5 million limit when they become liquidated post-petition? It's the same issue that happens in a Chapter 13 case or even a Chapter 12 case. So you may meet the criteria for being a debtor and proceeding under that chapter, and then you make it in the room. Okay, you get through the door. And then after you get through the door, your plan should probably have some provisions to accommodate that if that non-contingent event triggers and it becomes reality. Okay, so again, just look at the exact same thing that happens with contingent debt in like a Chapter 13 that might otherwise bust the debt limits. Okay, the next question down, I'll tell you, we are definitely going to deal with in the third session. But the question says, is there any relief for personal guarantee by the owner of a debtor, which is common in an SBA loan? Okay, so what that question deals with is a very, very hot subject right now in Chapter 11 world, and that is third-party releases. So our next session will deal with that in more detail, complete with copies of plans and provisions from plans. But here's the way the rule on that works. There is great division amongst the circuits with third-party releases. The majority of the circuits hold that you can do a third-party release. There's a minority of the circuits, including some big ones like the Ninth Circuit where I'm at, that say that you can't. And the reason why they say you can't is because it provides a non-debtor with the benefit of the discharge, according to the reasoning of the circuit. But having said that, the courts do tend to draw a distinction between a consensual release and a non-consensual release. If you're trying to force it on a creditor against their will, the courts usually will not allow it. But if it's consensual, then they often will. And one of the things that will make it consensual is that it be narrowly defined, limited to some particular circumstance, and that there be an opt-out provision. So if the creditor can say, I don't want to do that, then it becomes consensual if they stay in. So we'll look at that again next time around, but that's what you'd have to deal with, are third-party releases. So it looks like my host has joined us back again. Are we needing to wind down?
No, we're fine. If we have more questions, let's by all means, let's answer those.
We got a couple more. So let's take a look at just a couple more here, and then we'll be out of time, I think. Okay, so the next question says the best interest of the creditors test continues to apply, so the debtor can't retain excess assets equal to the value greater over 3 to 5 years if the creditors would receive more in a Chapter 7. Is that correct? Yes, it is correct. So the reason why you can use the liquidation analysis, you calculate out what the distribution to your creditors would be in a Chapter 7 case. After you determine what the distribution would be to a creditor in a Chapter 7 case, that becomes your minimum distribution under 1129A that have to go out to creditors in your sub 5 case. You use the kind of the slush fund provision that says that I need to hold on to money that's necessary for the continued operation of the business. You use that to effectively shield surplus future income that would otherwise end up being routed to your creditors. Because remember, you have to pay your creditors all of the disposable income over the projection in order to meet the fair and equitable standard. So you do have to meet the liquidation analysis, but what you want to do is protect the debtor from being cash strapped for 3 years and struggling to survive by adding that provision in there that will enable them to kind of hold on to some extra funds. Okay, and then the last question that we have says, because the Subchapter 5 trustee is a facilitator or mediator as opposed to taking over the estate, who investigates Chapter 5 actions? What's the creditor's recourse if they suspect a debtor in possession hasn't done a diligent inquiry into avoiding transfers? Who investigates questions about the estate assets and things of that nature? Okay, the answer is that's still the Subchapter 5 trustee's responsibility. And also kind of looking over your shoulder the whole time is still the U.S. trustee. So the Subchapter 5 trustee can, in fact, speak up and say, hey, wait a minute, we have some avoidable preferences that need attention here. And those would be disclosed or should be disclosed on the Statement of Financial Affairs in the petition anyway. So those kinds of things can certainly come up at the 341. And the U.S. trustee is likely to bring them up. And most judges in their initial status conference will ask specifically about that. Remember, Subchapter 5 requires there to be a status conference within 60 days of the filing of the petition. And most courts that I have seen have a required format for that report that specifically requires discussion of avoidable preferences. So remember, you still have to be a good faith debtor, right? So the bankruptcy code is designed to provide relief to the honest but unfortunate debtor. And so if you are in fact that honest but unfortunate debtor, you know, the bankruptcy code is there for you. Okay, but don't be a bad guy. If you're a bad guy, the court will smack you down, and that will not be good. All right. Anything else? Okay, I'll turn things back over to our host.
All right. Thank you, everyone, for attending. Thank you, Michael, for putting on a really informative session for us. We're looking at probably doing our third session somewhere in first part of December. So we'll hope that all of you can attend that. And we'd like to hope that you guys take a look at CPT Group for your notice and claims needs in the future. And everyone have a great day.
Thank you.
Thank you, guys.
Thank you.
Thank you, everyone.